Hello friends, in today's session we are going to discuss the case New Horizons Limited and others versus Union of India. First, let us briefly understand this case. In the case of New Horizon Limited and others versus Union of India 1995, one company LJ 100SC, there was a dispute regarding the eligibility criteria in the tender invitation for printing, binding, and supplying telephone directories, specifically concerning the bidder's experience and the transparency of the royalty determination process. New Horizon Limited, which was a joint venture formed by Thomas Press India, Living Media, Word Media, and Integrated Information, was rejected on the ground of lacking individual experience, even though its major shareholders possessed sufficient experience. The petitioners alleged a violation of Article 14 of the Constitution and arbitrariness. However, the Supreme Court held that the experience of the company's components should be considered, and that if a judicious decision had been made, their bid would have been accepted, resulting in a higher royalty. Yet, due to the ongoing publication process and the risk of heavy losses from the immediate stoppage, the order came into effect from 1995 and the appeal was sustained. Let us now study this case in detail. Answer: New Horizon Limited and others petitioners versus Union of India. Respondent. Reference 1995, one company LJ 100SC. Subject matter: this case pertains to the invitation of tenders for printing, binding, and supplying telephone directories. The key issue revolved around the eligibility criteria, particularly the requirement of experience for bidders and the process of determining royalty. It also involved allegation of arbitrariness in the selection and violation of Article 14 of the Indian Constitution, right to equality. Fact of the case: the Department of Telecommunications Hyderabad issued an advertisement on July 20, 1993 in various newspapers inviting sealed tenders from eligible agencies for the printing, binding, and supplying of telephone directories in English. It was mandatory for the bidder to specify the royalty amount for each issue. The advertisement also stated that the bidder must have experience in the compilation, printing, and supply of telephone directories for large telephone system, and documentary proof of the same must be provided. The bidders were required to deposit ₹5 lakhs as a non-refundable earnest money deposit, and the last date for submission of tenders was May 14, 1993. The petitioner, Messrs. New Horizon Limited, NHL, and Messrs. M&N Publications Ltd, Respondent No. 4, submitted their respective tenders. The Tender Evaluation Committee accepted the proposal of Respondent No. 4 while rejecting NHL's proposals without providing any specific reason. Consequently, the petitioner filed a writ petition in the Delhi High Court seeking the cancellation of the awarded contract. The Tender Evaluation Committee rejected NHL's bids on the grounds that it lacked sufficient experience as a company, even though its members had credible experience and were pioneers in the business. NHL was a joint venture company formed by Thomas Press India, Living Media India Limited, LMI, Word Media Limited, WML, Integrated Information Private Limited, IIPL. The petitioner argued in the High Court that NHL fully met the eligibility criteria outlined in the tender and had the capability to complete, print and supply telephone directories. The company also had the backing of experienced stakeholders such as foreign collaborators, equity holders and leading Indian shareholders TPI and LMI, who had advanced printing and binding facilities and had successfully completed similar projects for Delhi and Bombay telephone directories. The petitioners senior counsel contended that the contract was awarded to respondent number 4 based on arbitrary criteria, violating Act 14 of the Constitution of India. The High Court held that the lack of experience of the joint venture company NHL led to the rejection of its bid at the initial stage, preventing the authorities from considering its higher royalty offer compared to respondent number 4. Key legal issues and questions. Number 1. Can the experience of shareholders and the experience of the company NHL be considered separately? Point number 2. Did the tender evaluation committee respondent number 3 act arbitrarily or with the favoritism in awarding the tender to respondent number 4, thus violating Article 14 of the Constitution? Point number 3. In matter of public interest, should experience be given priority or should the higher royalty or revenue offered be considered as the primary factor? Point number 4. Should the principle of lifting the corporate will be applied only in cases of fraud, or can it also be used in cases where justice is being denied? Was the Delhi High Court correct in including that New Horizons Ltd NHL was not a joint venture but merely a company with foreign equity participation? Point 6. Despite the significant difference in royalty amounts offered rupees 3.65 crore, was the tender evaluation committee justified in prioritizing experience over financial considerations? Arguments by the petitioner. The petitioner contended that NHL was a competent and eligible bidder capable of fulfilling the contractual requirements. It argued that it offered higher royalty than respondent number 4, making it a better financial choice. NHL was a legally approved joint venture company by the Indian government. The company and its stakeholders and substantial experience in printing, publishing and marketing telephone directories. The rejection of NHL's bid was arbitrary, unreasonable and without a valid reason, amounting to misuse of discretionary power. Arguments by the respondent. The respondent countered that NHL lacked the required prior experience in printing and supplying telephone directories for a system of 50,000 lines. The petitioner failed to provide documentary evidence supporting its claim experience. The printed sample submitted by the petitioner revealed that the Delhi 1992 edition of the telephone directory was not published by NHL but by another company named Sterling Company. Therefore, NHL did not meet the eligibility criteria specified in the tender invitation. Judgment. For a legal standpoint, the Supreme Court concluded that while the tender advertisement dated April 22, 1993 mentioned the requirement of prior experience, the experience of NHL's stockholder TPI, LMI, WML and IIPL should have been considered even if NHL itself was incorporated only in 1992. The Supreme Court applied that lifting the corporate veil doctrine and held that if the tender evaluation committee has made a business-minded decision, it would have accepted NHL's bid. Had NHL been awarded the contract, it would have resulting a financial benefit of rupees 365 million, rupees 3.65 crore in royalty over 3 years 1992 to 1995. However, considering the practical circumstances, the Supreme Court also observed that the 1993 and 1994 telephone directories had already been published or were in the process of being published. Cancelling the contract at this stage would cause severe loss to both the department and the respondent. Final verdict: the Supreme Court's order came into effect from 1995 onwards, ensuring that such issues were prevented in future tender evaluation. This appeal was sustained. Please watch full video, share and subscribe to the channel. Thank you.